Hello everyone and welcome to another HR Employment Law Weekly Update. If you haven't seen me before, my name is Amy and I post content across social media platforms delivering HR and employment law content in a comedic and interesting way, that's what I try. I am also an independent HR consultant. I offer outsourced HR consultancy and one-off consultations. Any service related to HR, you can be sure that I provide it, so drop me a message, put the link to my link tree in the description box below and you can get in touch. Today we're going to start as usual with an Employment Rights Bill update. So the Employment Rights Bill is currently in the House of Lords at committee stage. As I am filming this right now, it is the 3rd of June and there is currently a sitting scheduled for 2:30 today. Next, we've got one on the 5th of June and potentially a further sitting on the 10th of June. The bill has already passed its second reading and is undergoing line-by-line examination in the committee stage. The committee stage allows for a more detailed scrutiny of the bill, including considering amendments and new clauses. Once the committee stage is complete, the bill will move to the report stage and third reading before entering the ping-pong stage where it goes back between the House of Commons and the House of Lords. I just want to give you a really quick recap from the sittings that have already taken place. On the 8th of May, 0 hours, low hours, agency workers, flexible working and the removal of the waiting period for statutory sick pay were debated and agreed, with some amendments added. On the 13th of May, statutory sick pay, tips and gratuities, parental, paternity and bereavement leave were debated and agreed, with no further amendments put forward. On the 19th of May, the debate focused on the changes to harassment in the Employment Rights Bill. There were lots of concerns over the implications that third-party harassment, compensation and other factors are going to deliver. But Clause 20, 21 and 22 of the Employment Rights Bill were agreed. So that's third-party harassment, regulations for employers to take reasonable steps to prevent sexual harassment, and automatic unfair dismissal for fire and rehire, all agreed by the House of Lords. On the 21st of May, there were many more amendments proposed in terms of health and safety, a duty for employers to prevent violence and harassment in the workplace, providing the HSE with more power to oversee employers' adherence to this commitment, and in terms of political beliefs as related to discrimination and enhancing statutory maternity leave protections. Clause 23, which relates to collective redundancies handling, that was agreed. Clause 24 related to pregnancy dismissal protection, that was agreed. And Clause 25 of the Employment Rights Bill related to public sector outsourcing, protection of workers, that was agreed also. So in terms of what else has been happening recently, many of you, if not all, will be aware of the Supreme Court decision on For Women Scotland Limited against the Scottish Ministers on the 16th of April 2025. I will be publishing an update on what this now means for employers in the next few days. Make sure you're subscribed if you want to see that. But now we're going to move on to Employment Tribunal news. So there was a tribunal claim reported in The Guardian a couple of weeks ago. The title referring to an employee who was working from home because he had gardeners at his house, contributing to the successful constructive unfair dismissal claim that he brought. But as usual with the tabloids, this was a tiny fact of the entire case and definitely not one that was representative of the deciding factor to determine the success of the claim. So the claimant was undergoing a mediation process with another colleague in work. There were a multitude of issues, personality clashes, work-related clashes, communication issues, which ultimately contributed to the claimant resigning and claiming constructive unfair dismissal successfully, and being awarded just over £30,000. One factor discussed was indeed the issue that the claimant was due to attend a mediation meeting with his colleague and requested to hold this from home because he had gardeners working there. The colleague he was due to meet was disappointed. There were arguments he wasn't taking the process seriously, and the claimant admitted in hindsight that it wasn't the right approach and did actually attend the office. I know it takes time to go and read the whole case that the tabloid publications of tribunal judgments put forward, but it is very important not to rely on them because usually they'll find the most interesting part of the case to sell a story, and it doesn't always accurately portray or represent the claim. In this situation, the claimant was awarded a 15% uplift on his compensation for not following ACAS code of practice, which personally for me is more interesting to hear, but I appreciate not interesting for the masses. I'll put a link to the press article and the actual judgment in the description if you want to have a better read. And just as a tip, if you're ever reading a news article and you want to find the actual case, just look for the surname of the claimant in the article and the company name. Type into Google surname against company name, so surname v company name, Gov judgment, and it'll come up and you can have a better look. The next tribunal case we've got involves TUC, Trade Unions Congress, which is a national trade union centre, and this is a big one. So yet again, another trade union ending up at tribunal for not conducting a dismissal process properly and fairly. If there's one organisation that you would think would get this right, it's a trade union organisation, but evidently not. So TUC have been ordered to pay compensation to 2 employees totalling over £100,000, and at the heart of the claim, the General Secretary, Mr. Nowak. The main factors in this decision were that the disciplinary and the appeal had involvement from the same person. This is basic understanding in HR. You don't have the same person involved in both the disciplinary and the appeal, and that's absolutely unavoidable. And for a large organisation who had other options, this is indefensible. Not only that, but Mr. Nowak, who had involvement in assessing and approving the dismissals, and then subsequently the appeal, was appointed as a member of the ACAS Council in November 2011. ACAS, if you don't know, are the organisation who published guidance on disciplinary procedures for employers to follow. So him being a member of the ACAS Council is quite significant. For me, it begs the question, was this deliberate ignorance or a lack of awareness? Because I cannot comprehend how a professional in this capacity could have such lack of awareness. Is it just a case of non-compliance? If so, it's come at a cost to the trade union. There was also a failure to provide evidence, and the employees were stated to have been dismissed for a breach of policy, which didn't exist, but there were deductions for contributory conduct at the tribunal. The tribunal were pretty scathing of the behaviour, stating that they were unreasonable failures on any view, but more so when considering that this was an employer, which, because of its nature, should have had a much better grasp of the ACAS code. I'll put the link to this news story and the actual judgment in the description below. Next tribunal has hit headlines for a missing mug, as in a coffee mug, being the main factor in a recent claim, but I'm much more interested in the award that was paid for breach of contract. The claimant was awarded £1,210 as damages for notice paid that he should have been awarded. He worked at Curry's as a credit support associate. He made claims of race discrimination, sexual harassment, failure to make disability adjustments, and unfair dismissal. All of those were dismissed, and the unfair dismissal, he hadn't been there for the required 2 years length of service. In relation to the race discrimination was the mug incident, which the mug in question went missing as it was left in the communal area and was potentially used by someone else, to which the claimant was upset and went to search for the mug, and the colleagues were likely to have viewed that as him suggesting that they'd stolen the mug. There were arguments of social exclusion following this from his colleagues, but the tribunal heard that the claimant was still part of a WhatsApp group and invited out to drinks, and even though the claimant argued that he had been cold-shouldered by colleagues. He also alleged that there was a sexual harassment claim, that a colleague had asked him why he didn't have children and, as quoted in the tribunal, rubbed her bosom against him, leaving an empty drink bottle on his desk called Juice Burst, which he argued had a sexual connotation. Go figure on that one. The tribunal found these claims to be incredible and dismissed them. Overall, in terms of the breach of contract, the company wrongly paid him notice pay because they ignored that the contract was silent on notice pay during the probationary period and should have paid him 1 month in accordance with his contract rather than the 1 week in what they actually paid him. So he got 3 weeks notice pay. Again, I'll put the link to that in the description below. And that brings me to the end of this week's video. I hope you enjoyed. I will be watching the debate today on the Employment Rights Bill, and I will update you next week as to the next sittings and any relevant tribunals. Hope you all have a great week. Take care, anyone. Any feedback, as always, put it in the description box below. And if you want to contact me, you know where I am. Okay, take care, guys. Bye.